Good afternoon, everyone, and welcome back to this week's episode of the Digital Law News produced by Anson Evaluate. I'm Amelia Davies, an apprentice solicitor at Digital Law UK. I'm joined by my colleagues Peter Wright and Heather Anson, who are going to run through some news stories which will be coming up this week. I'll pass over to Peter to introduce himself and Heather, and then we'll get started.
Hi, my name is Peter. I'm a solicitor and the Managing Director at Digital Law. I'm looking forward to be able to go through some very topical news issues with you all this week.
And hi, I'm Heather. I'm the Managing Director for Anson Evaluate and a US qualified lawyer. And I do multinational law, which is why I'm here for the first story.
Thanks, Heather. So that leads us nicely into the first story. So we are looking at essentially France versus the EU. So for context here, the European Union's top court has reaffirmed that a national law cannot rely on a claim of combating serious crime to deviate from the prohibition in EU law on general and indiscriminate collection of electronic communications data. So I'm going to smoothly pass over to Heather to really nicely unpack this and explain it in a way that probably people can understand it, because I certainly didn't understand that.
Well, the EU said that France, you have to do this. You have to actually comply with this regulation that says you've got to limit data. And now they're coming back. What's really interesting is what they've come back with, which the story leads into, which is they want their court to rule that the way they handle this data is part of what's called their constitutional identity. And this is a legal term that is becoming more and more popular over the last, I'd say, 2 decades, and was actually codified by the EU itself in 2006, specifically with Regulation 2020-2092. They talk about that in order for the EU to have a constitutional identity, they need to respect the constitutional identity of the individual states within it, which is some people who are not in favor of the EU might find that ironic. But interestingly enough, Hungary and Poland tried to get the EU, through the EU Courts of Justice, the EU CJ, to annul that regulation, to say that, or that directive, or it was a regulation, not a directive, sorry, there are so many different things there. They wanted them to annul that, saying that it didn't follow EU's constitution, EU's treaties, and whatever. They said it's being abused, and specifically they said it was being abused by individual states who were justifying their, quote, illiberal and autocratic ways. So they didn't like what countries were doing, and then saying it was their identity, their constitutional identity, therefore they didn't have to follow this particular law of the EU. And Hungary and Poland thought for sure the EU CJ would side with them and say, look, these countries are doing horrible things and doing it in the name of constitutional identity. And they thought for sure they would win it. And on the 16th of February this year, the EU CJ said, actually, no, we're doubling down on this. We're saying that not only are we not getting rid of this regulation, but it is something that is couched in the Treaty of the European Union, that this is something fundamental and necessary for the EU to exist in order for it to have its identity. So I think once that decision was made, France then decided that this was the best way, because they've been kind of sitting on this for a while. They've been told for a while that they needed to change their ways, as it were, with the retention of data, particularly around security, and they've kind of ignored it. And now they're actually being proactive. Instead of just ignoring it, they're saying, actually, we're going to get our high court to rule that it is part of our constitutional identity to have this type of data retention, particularly at the state level for surveillance. So does that help?
It does, and it's interesting. I think when you put it into the context, as you were saying there, about France's actions in recent years. I mean, over the last decade, when you look at some of the quite serious terror attacks that France has sustained, everything from the Bataclan to Charlie Hebdo to various other atrocities, they've ended up developing, I think, some quite serious surveillance infrastructure to try and prevent any further or monitor any risk of any sort of further attacks. And that's what this judgment from the CJEU comes down to, insofar as France is increasingly using these tools for the reasons of surveillance. And then you've got the court saying, well, we aren't very happy with this. And then it's fascinating the balance in terms of France then saying, well, we want to opt out of this and potentially want to take it further. And then the potential massive implication for the EU of France turning around and doing that when you've got rule of law enforcement currently taking place against Poland and Hungary. Let's not forget those two countries that are currently sheltering hundreds of thousands, potentially millions of refugees from Ukraine, and yet they're currently facing enforcement from the EU over perceived rule of law issues. So there's some fundamental tensions there at the moment, and this is sort of adding a significant amount of spice to an already combustible mixture.
Yeah, and the interesting thing is actually you can start identifying states within the EU and how they view constitutional identity in terms of the state towards the EU. Interestingly, Germany and Hungary, it's weird that Hungary was actually in favor of annulling because they've been sort of positioned as using constitutional identity as confrontational to the EU, Germany and Hungary both, whereas other states like Italy have used it as a means of conformity with. So saying we're using constitutional identity to conform with EU law as opposed to confront the restrictions of EU law. So this is another, I would say, another fissure sort of in the interpretation of what the EU is there for. And what its purpose is, and some clear disagreements that are getting much clearer and starker between the different states in it. So if this isn't, I believe that if things like this aren't resolved soon, and if France being slightly more high profile than I think some of the other obvious cases of the uses of the constitutional identity, this is going to be more high profile. So if they are able to say, we get to do this on something as present as data retention, data privacy, data retention, which is on the minds of so many legal professionals right now and the public, that will lead to the increased use of it. They'll say, oh, look, it worked for us. And lots of countries who disagree with a lot of the things that are happening will say, well, then, yeah, that's us too. This is identity. So that could severely weaken the EU's authority. And if they aren't careful and if they aren't consistent with it, it could also cause a lot of tension. Anyway, that's my 2 cents on that.
Thanks, Heather. That was great, and thank you for joining us today. No doubt we will probably hear from you in another podcast soon, and I will shortly forward us into our next story for today.
And I will leave you then.
Thanks, Heather.
Thank you. Have a great podcast.
So for our next story today, we will be looking at the ICO and the government really, and how the ICO have formed a report in relation to the government's use of WhatsApp and other similar messaging apps throughout the pandemic. And I use the term other messaging apps. I think it's very well known at this point that the government widely used WhatsApp throughout the pandemic. You only need to look at a few representatives of Parliament to see who has been taking screenshots. I won't mention any names there, Peter, but we all know who they are. So I will pass this over to you to get started.
Thanks, Amelia. Yeah, so this is really drilling into the heart of the fact that over the last couple of years, we've had lots of examples of government communications, government interactions between secretaries of state, prime minister, ministers, civil servants appears to have all been taking place on WhatsApp. We've had lots of screenshots submitted when it's come to parliamentary select committees that have been looking into what went on during the pandemic, and a culture of government by WhatsApp seems to have been in evidence across Whitehall. Now, regular listeners and viewers will be familiar with the fact that we've talked about the fact that WhatsApp is not suitable as a communications tool for business-related purposes if you are in a highly regulated sector. We've talked in the past about the fact that the National Cyber Security Centre specifically says do not use WhatsApp for business-related purposes. The British Army has issued guidance to say that its troops should not be using WhatsApp because of the security issues around it, not to mention the elements of GPS tracking as well. So it's been very, very clear from certainly the security apparatus of government has been saying you shouldn't be using WhatsApp. And yet at the same time, we've been seeing stories in the press with all of these screenshots from WhatsApp communications. Well, new ICO, John Edwards, came in January, and now within a few months, he's now turning around and saying, look, we are looking heavily at the fact that the Department of Health and Social Care, the department that runs the National Health Service and social care, so one of the departments with one of the biggest budgets, and one of the most important departments when you think that, it's one of those departments running something that virtually everyone at some point in their lives will need some service of some more form or another from the NHS. So something we all come into contact with. And then it's saying here, look, they've clearly been using data in a manner that is not suitable when it comes to using WhatsApp. So the ICO is now kicking off. It's issued the results of its year-long investigation, and there is it's produced a real risk of important communication during the pandemic potentially being at risk and potentially being insecure. And when we look at the fact that lots of things like the development of the vaccines, it is thought there was probably a lot of state surveillance from other interested countries interested in what the UK was doing and interested in what the West was doing as a whole with regards to the development of vaccines. And if all of this is being handled on insecure platforms, you can imagine that there was a significant risk of possible surveillance by other state-sponsored actors. So that's why they zeroed in on the Department of Health and Social Care in particular. So they've now said that the DHSC should be improving its practices. A reprimand has been issued. They're trying to ensure that more lessons are learned. But this is a big indicator from the ICO to say across government, across Whitehall, you shouldn't be using WhatsApp. And for anyone who doesn't work in government, is thinking, I use WhatsApp in my business, for the avoidance of doubt, I'd say don't use it. Certainly if you are in a highly regulated sector, so if you're practicing anything from law to medicine to accounting to financial services, if you're in a highly regulated sector, you should not be using WhatsApp for business-related purposes. You also shouldn't be using Telegram because that's even more leaky. There are other alternatives out there that are secure. They're probably premium, so they might cost a little bit, but at least you're able to demonstrate I am not using WhatsApp. Do not forget as well that WhatsApp was fined €250,000 last year by the European data protection regulators, and you can see it quickly becomes apparent that it is simply not suitable for business-related purposes. For the avoidance of doubt, I wouldn't even use it for sort of sharing things like bank account information, sort codes, accounts. I know people very often set up groups for the purposes of organising holidays and travel. I wouldn't put financial data in there. I'd think very, very careful about putting in personal identifying information as well. So if you're thinking of sharing holiday snaps or anything like that, I'd think twice about it.
Thanks, Peter. I think it's key to mention here that there are other apps, like you say, that can do all of the same things, such as Signal. I know that we as a firm, we have been using Signal and it operates in the exact same way, but there is the fact that all of the messages or any sort of communication is just stored on that device. Nothing is being stored on the cloud, and therefore, unless someone physically takes your device and breaks in that way, your chat and whatever you've sent is safe. I think that's a really important thing to flag here.
Indeed, I mean we've been evaluating Signal and it seems to work well and appears to be recommended. I think again it was either the British Army or MI5, one of them recommended Signal as an alternative. So we've been sort of evaluating that, but certainly long term we've been using BlackBerry Enterprise Messenger, which seems very, very boring as a platform now. BBM was a thing before WhatsApp, and Enterprise Messenger is the successor. But we've always found it to be a very secure platform, and certainly something that's worked well for our internal comms, both before and in particular then during the pandemic as well.
Thanks, Pete. That nicely funnels us on to our next story, which is looking at the online safety bill. So I think we've discussed this in a few podcasts. It was not necessary to really go through this in much detail, aside from the fact that this has now been delayed. And this is because of the change in Prime Minister. So the online safety bill aims to kind of lay down new rules and about how platforms should deal with harmful content. And it had been in its final stages and was to be discussed in Parliament next week, but it is now been paused until MPs are returning from their summer break. So, well, there's not much of a news story there. It is just a bit of an update on that.
It is, but I think it is a important piece of legislation insofar as it is thought to have significant potential limits on freedom of speech contained in it, because it is trying to create a system and impose and regulate a system of content management on platforms like Facebook and others. There are a lot of people, from journalists to comedians to privacy rights campaigners, who've said, look, reading between the lines here, there are potential powers within this legislation that mean that you could have a chilling effect on the freedom of speech in terms of the definitions, in terms of what's hate speech, what isn't hate speech, what can you and can't you say. And the problem then becomes, I mean, the government keeps on giving assurance saying, oh, no, we won't possibly use it in that way. But the journalists are saying, well, that's all well and good. You're saying you won't use it in that way. But what happens when you go and then another government comes in and decides, well, actually, we're going to use it in a very, very different way? Because once these things are on the statute book, they are then open to interpretation. And that's where the problem comes in. So it's very significant that this isn't now getting its reading next week. This was very much becoming a sort of quite a totemic bill for the outgoing administration under Boris Johnson. The Health Secretary of State pushing it forward was Nadine Dorries, who was ramming it forward despite all of the objections, and it would probably have passed in the course of the next few weeks, despite probably a lot of objections and a lot of rebellions along the way. Don't forget, with a big majority, it takes an awful lot to stop the progress of a piece of legislation that the government makes totemic and says, we want to get this through, and puts a 3-line whip on it, which it would probably have done. Then it's become interesting that then we're currently now in the world of leadership, a new leadership race in terms of who the next Prime Minister will be, so the next leader of the Conservative Party and Prime Minister. So there are a number of candidates. We've had another vote today, and there will be more and more votes, whittling them down to 2 candidates, and then there'll be a vote finally by the Conservative Party membership. But several of the candidates have made an issue of this piece of legislation, and particularly Kemi Badenoch, who has said that she feels that it is a piece of legislation that she is not in favour of and would not introduce, and certainly wouldn't be pushing through. So that's one of the reasons why the government has paused this, because it would not seem right for what is now a caretaker government to push through such an important piece of legislation if a successor Conservative Prime Minister was to be of the view that actually they were not in favour of this piece of legislation. So it's probably now actually a lot less likely at the moment that this becomes law. One of the reasons being is that it's probably quite unlikely that Nadine Dorries will continue at the Department of Culture, Media and Sport after the new government comes in. So it would have lost its main driving force. So you can see why, therefore, it's now no longer going through. And be interesting to see what happens now. Does it come back in its current form after recess, or does it come back heavily amended, or is it dropped in its entirety? That's one thing to see come September, when the MPs return from their holidays by the beach with their buckets and spades.
Thanks, Peter. Moving on to our next story. So this kind of crosses over what Heather was talking about earlier about kind of surveillance. So this is looking at Australian facial recognition. So Australia's privacy watchdog has launched an investigation into 2 retail giants over their use of facial recognition technology. Hardware firm Bunnings and department store Kmart collect some customers' face prints in some locations, and this is kind of to avoid theft and to improve safety measures. But as one might think, if you're going into a shop and someone's saying, oh look, Amelia's visited Kmart again today, I don't think you'd be all too pleased about being surveillanced in that sort of way. And so hence this investigation has been started. And interestingly enough, last year it was found convenience store chain 7-Eleven had interfered with customers' privacy by collecting face prints in a similar case. So it'd be interesting to see what happens with this one.
Indeed, thanks, Amelia. I mean, this is a fascinating story. We've had, certainly in the UK, it is known that in some areas, for example, football stadiums or areas heavy footfall around rail stations and airports, security services have trialled technology like this using facial recognition, and privacy campaigners were disturbed by the fact that very often the software would struggle with people if they were of a certain skin colour, certain complexion. It would tend to mean that the results would not necessarily be accurate. Surprise, surprise. So its use has been discouraged, certainly by state surveillance platforms in the UK. But this is the first time I've heard of it being used in a commercial setting, and you can see why large retailers would want to introduce this. I mean, for example, in the UK, particularly over the last few months where we've had a cost of living issue, some of the supermarkets have had a significant rise in shoplifting. And at the same time, sometimes we think shoplifting, it's more actual theft where people go and pick something up and then run out of the store. And having spoken to people who work in the stores, they're actually quite worried because they've been told, don't challenge someone, just let them go. And they're also finding that if they then report it to the police, they're not really bothered and not investigating. So that says a lot for the rule of law. Different type of rule of law perhaps, but nonetheless. But the point is, you can therefore see if you've got potentially an awful lot of money going out the door, you might be tempted to therefore engage in a form of facial recognition, so that if someone went and did that and runs off with a bottle of whiskey or something, the next time they come into the store, an alarm will be triggered and a security guard can say, oh, you're barred, you're not coming in. And you can see, therefore, this is quite important here, what's happening in Australia, where these 2 hardware stores have introduced this equipment and are now facing an inquiry from the Australian Information Commissioner. Australia, of course, isn't subject to the rather restrictive European data protection laws, but nonetheless, they're looking at issues around the principles of privacy and security, not to mention mass data collection and surveillance. So given that they're now facing this investigation, it will be interesting to see exactly what the view of the Australian Information Commissioner ultimately is.
Thanks, Peter. Moving on to our final story of today. Now, this is an interesting one, I have to admit. When I first read the story, I sort of had to read it twice just to digest this. So this is where we're looking at service by NFTs. So to set the scene here, an Italian engineer is trying to recover around 2 million of stolen cryptocurrency, and he has been given permission to serve high court proceedings via a non-fungible token, an NFT, on the blockchain, and his lawyers have said in English legal first. So this chap has been effectively conned by individuals who imitated online blockchain brokerage TD Ameritrade with their website TDA, and introduced him to transfer funds from his crypto wallet to trade on the platform before he realized he was a victim of fraudulent activity. And as we have mentioned before on this podcast, there are no real rules and regulations in relation to cryptocurrency. And therefore, upon hearing this in court, they found the best way to serve in this case is to use an NFT and put it out on the blockchain. So I will pass over to Peter to explore this in more detail.
Thanks, Amelia. I mean, it's fascinating here that the court has embraced this method of service. The High Court in England and Wales has been innovative in exploring different ways to undertake the service of claims in civil matters. Before, a few years ago, they authorised the use of serving a claim in a specific case via Facebook, because that was one of the only ways the claimants could verify the details of a defendant. So the court said, yes, in this instance, we'll let you serve using Facebook. And now here we are, 2022, and the court's saying, yes, you can serve the claim in this instance using a NFT across a blockchain. And that is, in the view of the court, going to be adequate notice of the existence of the claim. For the non-lawyers listening, the point here is that if you can then say, right, we have served the claim, even if the defendant wants to sort of put their fingers in their ears and go, la, 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 not listening, the point is that the legal proceedings can continue. So even if the defendant decides not to engage, doesn't play ball, doesn't answer any correspondence, doesn't attend any hearings, the claimant will then be able to get their judgment in default over the defendant. So then there would be a county court judgment, and you might think, well, so what? Well, the so what here is that if you've actually got a verified defendant, that will have an impact on their credit rating. It would mean that they would have difficulties in terms of access to finance, lending, being able to borrow, and in a time of high inflation, that's going to be something that most people probably need. So there is an implication here insofar as it is in a defendant's interest to play ball and to actually engage with the claim. And in this way, it's being made clear that they can't hide behind the fact that it was a crypto asset that was stolen. So in this instance, there is a clear issue here of fraudulent misrepresentation and deceit, unlawful conspiracy, unjust enrichment, and therefore they've said, yes, you can serve these proceedings via the non-fungible token, and then the wheels of justice will then continue to turn. So this will be an interesting one to follow. Will the defendants engage in these proceedings, or will they try and argue, oh, this is, we ignore this and hang the consequences? Interesting test for interest of justice and the rule of law, but also an example of the court engaging in technology. This is what justice systems have to do. It is no longer enough to rely on service of something via the post, which increasingly seems quite Dickensian in this day and age. It is no longer enough to rely on the process server who turns up, particularly in US dramas where they've got that whole "you've been served" thing, which is less popular over here, but certainly is an acknowledged way of being able to serve legal documents, because then you've got physical evidence of, look, filed, served, done. But the point here is you can do it all electronically. So no need for the intimidating process server, no need to worry about has it been served by the post. You can do it electronically, and the court is here engaging in this. Probably also important to realise here that the firm acting for the claimant has said this is the first time permission to serve court proceedings on an unknown fraudster by NFT has been granted anywhere in Europe, and it's the second time anywhere globally, given that the New York Supreme Court did something similar in June. So that was only in June of this year, and in July, the High Court in England and Wales is following suit, following the example set by the New York Supreme Court. So there is jurisprudence now evolving around the world, showing that you can do this, that you can therefore serve and give life to civil proceedings through using a non-fungible service via a non-fungible token, NFT.
Thanks, Peter. That's a really interesting story to end on. And do you think it could potentially make way for more regulations, since we've now seen NFTs coming up and kind of setting a precedent here? Do you think it would kind of lead the way for more regulation in this sort of area?
I think it is inevitable that there is going to have to be more regulation of the NFT market, given the quite incredible sums that are being invested in different NFTs by investors. I think we are also on the way to seeing greater regulation as a whole of cryptocurrencies, given that the market turbulence we've seen this year has revealed that there really is no limit to how low a cryptocurrency can fall. Nonetheless, it can then sometimes climb back quite quickly afterwards, as Ethereum has shown. But when you've got that inherent instability in the market, it will deter some investors from taking part. And I think a greater level of regulation being applied might lead to slightly greater stability. I think people thought that by the imposition of things like stable coins, you'd have greater stability across cryptocurrencies, but the way that some of those stable coins have fallen through the floor in the last few months has kind of blown that idea to pieces. So I think we are at a point where we are going to gradually see greater regulation as a whole. Let's hope that it doesn't use red tape to then stifle all the innovation out of the field. Ultimately, I think cryptocurrency NFTs are the future. But it's a matter of, are they going to be the future continuing at this massive level of investment, or will there be a bit of a decline before they are gradually coming back into greater use, perhaps in a slightly more regulated manner that will give investors and indeed marketplaces more confidence to accept and undertake transactions using that technology.
Thanks, Peter. So that was our last story for today. Big thank you again to Heather for joining us on that first story, and thank you to Anson Evaluate for helping to produce this webinar. We will hopefully be back next week. Just a reminder that these episodes are available on our website, our YouTube channel, as well as podcast channels such as Spotify and both Amazon and Apple Music. Thank you for listening, and we hope to see you again next week.